All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh, give their attention to the court. Now sitting. In.
Good morning. Wonderful to have all of you here. We have a very full courtroom today. We're excited about that and welcome all of you. I know we have at least one individual who asked for a tour of the Judicial Center independently of a group. Ms. Franklin, we welcome you and we encourage other Kansans to do the same thing, to come and visit our Judicial Center, and we do provide. We have some student groups. Would the professors from Washburn Law please come forward and introduce your groups? You could come clear to the lectern. You'll get on. It'll look much better on YouTube.
How wonderful. Thank you. We appreciate that so much. Your honors, I'm Professor Eunice Peters and I have Professor Kowalska with us, and we are here with our Washburn Law students, and we have our first year law students here with us today. We personally want to thank the Supreme Court, the clerk of the court, OJA, for helping us coordinate this experience. And we have reviewed the briefs our students have, and we appreciate the opportunity to watch today's oral argument, especially since their focus this semester is persuasive writing, and it culminates in a final appellate oral argument for them. So thank you so much.
Thank you for you and to all the students. Are there any other student groups? Okay. Again, welcome to all of you. With that, I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the morning docket.
Your Honor, may it please the court. The docket for Tuesday, January 31st, 2023 consists of two cases. First case, appeal number 123382, State of Kansas versus Alan Lee Busch, Seward County, briefs both sides.
May it please the court, Jennifer Roth here on behalf of Alan Busch. I'm present and ready for argument, and Chief Justice, if I may reserve 3 minutes for rebuttal, please.
Bank, Seward County Attorney representing the state and appellee.
Second case, appeal number 124676, State of Kansas versus G.O., Shawnee County, briefs both sides.
May it please the court, I'm Reed Nelson. I'm representing the petitioner G.O. And I am present, ready for argument, and I would like to reserve 2 minutes for rebuttal. Thank you.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. I'm present, ready for argument.
Your Honor, that concludes the docket for today.
Before I call the first case, I might just, by way of explanation, let those in the audience and watching on YouTube know that the justices are familiar with the facts of each case and with the arguments, the briefs that the parties have filed. We've reviewed those as well as portions of the record and case law, other things to prepare us for argument today. We look forward to those arguments and to the exchange we will have with the attorneys this morning. At times, you'll see us looking down as we make notes. We may be on our computers and you can see us. Often doing that was we consult our notes, checking something in a brief, looking at a case, a passage, a statute, something of that nature, or perhaps even looking at a portion of the record that's referenced. We do all of that to assist us in understanding and assimilating the arguments that the counsel are making. I just want to assure you that when we're doing that, We are focused on the case. We are listening, and very involved in the processing of the cases that are. With that, I will now ask counsel to come forward on case 12338.
May it please the court. Again, my name is Jennifer Roth. I work at the Appellate Defender Office, and I'm here because I represent Alan Busch. Mr. Busch, I'm just jump right in. As the court pointed out, I know you're familiar with the facts, and what we're here on is pretty limited. Mr. Busch argued to the Court of Appeals that the state had the burden to prove that his New Jersey convictions from 24 to 34 years ago, his prior convictions, should be scored as person felonies, and that it failed to do so because they do not require proof of any of the circumstances in the applicable statute, which is 216811 E3 big B. Mr. Busch was not alone in this belief. The state agreed with him that the current record does not contain substantial competent evidence that would support treating these 5 New Jersey convictions as person crimes, and asked for the case to be remanded. Then the Court of Appeals agreed to extent with Mr. Busch that the New Jersey statutes cover conduct beyond the circumstances in E3. But nevertheless, the Court of Appeals found that the parenthetical notation of residential satisfied this on the pre-sentence investigation report, satisfied the state's burden, and found the New Jersey convictions were properly scored as person felonies. So that brings us here today on one issue, and that is whether the Court of Appeals decision violated the 6th Amendment when it concluded that this notation in the pre-sentence investigation report that said residential in parentheses meant that the district court properly scored Mr. Busch's 24 to 34-year-old New Jersey burglary and criminal trespass convictions as person felonies. I would actually suggest that maybe it's even easier than I originally thought as far as how this case is resolved. And that is merely through the language of E3B. We acknowledge that the test for how you score those out-of-state felony convictions is now different. There is a circumstances test, and what that test says is it lists out, and I guess I should back up and say, this wasn't in our petition, but I'm familiar with how we came to have this test. I'm familiar with some cases about it. So if the court has questions in that regard, I am prepared for that, hopefully. But we acknowledge that the test is different, but even under the statute as it is now written, which lists out a list of circumstances that if they're present in the elements of the other state's statute, then you score them as a person felony. But that whole test, the whole scheme of it is in 3 sections. And the final section of E3B tells us that any out-of-state conviction for the commission of a felony offense shall be classified as a non-person felony if the elements of the offense do not require proof of any of the circumstances in subparagraph B1 or 2. And that is what we have here. What we have is when we look at the New Jersey statutes that are in, I believe they're in the petition as well as the brief, that when we look at the circumstances and when we look at the New Jersey statutes and what burglary requires and what criminal trespass, what the elements of criminal trespass and the elements of burglary are, and when we look at the circumstances and when we look at E3B as a whole, we can see that the new elements of the New Jersey statutes do not require proof of any of the circumstances in the rest of that statute.
Counsel, is the use of the term circumstances suggest a factual inquiry or an elements test?
So I keep calling it the circumstances test because that's the word that's used, but essentially it is a list of elements. Yes, it's a list of elements. And I would say that because, well, I think that's what it needs to be, but I also think that that is what it is. And additionally, the proponents of that test wanted it to be constitutionally valid. They wanted it to be presumably easier. And so I believe that it is elements and not facts.
The defendant stipulated that he had a criminal history of A. How does that affect our analysis?
So the way the Court of Appeals looked at it is that my client did not actually do anything. His attorney, when the court said, do you agree you're an A? His attorney said, yes. And my client didn't object or agree personally to anything, which is why the Court of Appeals reached that issue, as opposed to saying you're out of here because you agreed. And so I believe that that is a difference. But even if this court sees otherwise, that somehow or another my client's lawyer answering for him, if the court sees otherwise, I don't think that Mr. Busch still prevails, because even if the burden somehow shifts to him, which I would go pretty close to saying that I can appreciate that. And if the burden does shift to him, that he still prevails merely by looking at the New Jersey statutes and looking at what the current test is, and that he would meet his burden to show that those should not be scored as person felonies.
Is there a distinction between the criminal trespass and the burglary statute? That it seems like there is.
Yes.
The elements of the criminal trespass includes a dwelling element,
Right.
which
So
seems to put it in a different analysis than the burglary, at least as I kind of look at the surface of this.
Right,
And
so-
I guess I don't have as much of a problem with categorizing the criminal trespass as satisfying the statute as opposed to the burglary.
right. And in our petition, we do acknowledge that to the extent that it still makes a difference, which I think it does, to the extent that it still makes a difference that we are not allowed to engage in impermissible fact finding.
Right.
That the thing about the criminal trespass statute is that it is divisible in a way that the burglary one is not. And so I agree, Justice Rosen, that there is a means there's a way by which a person can commit criminal trespass that would involve a dwelling. So yes, so in that way, I still think that and I guess in a way, so does the state, that even when we are talking about the criminal trespass, that there was not substantial competent evidence to add residential in parentheses to that conviction. And furthermore, the only way to arrive at a parenthetical notation is to engage in impermissible fact finding. But actually I back that up because it's a divisible statute, then that's why I think it would be okay to send it back to have a court decide whether they can permissibly find that it is a conviction under the statute that talks about dwelling, or the subsection that talks about dwelling. Sorry. Okay.
So understanding of the New Jersey statute is that if the 1989 version was convicted offense under this subsection, the crime of the fourth degree if it is committed in a dwelling. Otherwise, it is a disorderly person's offense. So why do we need to know anything more that it was a conviction for trespass and not a disorderly?
Why do we need to know? Because a disorderly.
Just the label of the conviction, the PSI shows, I believe, that it is a criminal conviction of that would fall within that fourth degree of, so that we would know it was a dwelling. as opposed to not labeling it as a disorderly offense.
Bill? It is on the PSI as 18-3A. And in 3A, as the court just mentioned, there's different ways that you can commit the thing under A. And one is if it's committed in a dwelling, otherwise is a disorderly person's offense, which under New Jersey law isn't even scorable or wouldn't be scorable in Kansas. So that's why I think it makes a difference, if I understand the question correctly, that even when you look at the statute cited in the journal entry, it says A, and A has these two ways. One way it wouldn't even be scorable, one way it could be a dwelling. If your question is, well, it says residential in parentheses, and I would just point out, there's no word residential in 18-3A. There's no residential mentioned at all in the New Jersey statutes. They don't use that word. And so I would go back to this idea that there was not substantial competent evidence. We don't know how this parenthetical notation came to be, which even the state agrees that there wasn't substantial competent evidence to support that.
Does that matter if the meaning of structure in the New Jersey statute includes residences?
Right. Do you mean with regard to the burglary and the criminal trespass, or
Well,
just the criminal trespass?
Let's just talk about the burglary, I guess.
I think that it does matter. And that is because if this court, it's like I was saying at the beginning, the circumstances test is there in E3B, and that has 3 different subparts, as I recall, which I am sorry, I didn't put that one in my petition, but it's in my brief. But that test has I, which lists out the circumstances. It has double I, and then it has the triple I, which is where the whole statute ends and refers back to I and double I by saying that if the out-of-state conviction, shall be classified as a non-person felony if the elements of the offense do not require proof of any of the circumstances in B, I, or double I. And so that's why it matters. When this court is, I think it's safe to say, big on looking at statutes. I'm afraid I'm going to mess this phrase up, but in pari materia. And so this court is big on that. And so I doubt that this court would approve of us just reading I and stopping there.
Does the statute contradict itself? Because the language the Court of Appeals relied on is not the language you're talking about in the statute, right?
Right.
That's the language that says we have a phrasing in the negative and then we have a phrasing in the positive, right? Sounds to me like your argument is essentially that those two provisions conflict with each other, because the positive phrasing says if one of these circumstances is covered by the out-of-state statute, it is a person felony. Am I reading this wrong? Or?
Yes, no, I think that you're right. The reason I guess that I didn't think about them conflicting and just always thought about, I don't know if it's triple I don't know how you would refer to that subject. At any rate, is because I know what the intent of this was. And so when one looks at which I'll admit is not in the petition, but when we look at what the intent of this was not the original Wettrick fix that was proposed to the legislature in 2019. And instead, a group of prosecutors put forward this circumstances test. And in so doing, they said, both to the House and the Senate, that we believe it's the stated policy of the state of Kansas that a prior out-of-state felony that necessarily requires proof of any of the following should be treated as a person felony. And so I never thought about them contradicting until basically recently. And so to the extent that we think that I and triple I conflict, when we read that statute as a whole, we believe Mr. Busch prevails, that you do not necessarily have to prove any of those circumstances to find New Jersey burglary.
I have one last follow-up to focus on the Court of Appeals reasoning on this question. And at the bottom of page 6, top of page 7, the Court of Appeals says basically Kansas recognizes burglaries of residences as person felonies. And then they say on the face of the New Jersey statute, Busch was convicted of an offense that encompasses both residential and non-residential structures. That seems to me to be a logical way to read little I in the statute. Would you agree with that? And I understand you say, well, wait a second, look at triple I, but.
Right. I'm going to look at page 6 really fast. Right. So you're saying that if I just read I by itself.
Right.
And it says residence and structures by whatever have to require that. I have to say, you're not wrong.
Yeah,
I mean.
It does seem like there's a.
It's right. I mean,
There's a
where
contradiction.
else is it dealing with a structure? But again, I go back to this, number one, what the intent of the offers were that was then adopted by the legislature in adopting this test, and also what it says in 3.
So just to put us in our statutory construction framework, it strikes me that in the course of our conversation over the last few minutes, if we're right in our discussion, at a minimum, this creates an ambiguity in the statute. Would you agree with that?
Yes.
Thank you.
Yes. And, yes. Sorry, I see I'm out of time.
I have a question, if I may. Criminal trespass statute going to Justice Luker does include residents, but then it depends on the level of severity it is, whether it's disorderly or level 4. Would it be appropriate for the district court to look at the sentencing journal entry, determine what sentence the defendant received in order to determine, without fact finding, whether it was disorderly or a level 4?
That is interesting. I hadn't thought about that. I mean, it says that in certain situations, we can look at certain documents. And again, as I was talking earlier, I have to admit that criminal trespass is a divisible statute, where you could look to these other documents. So I guess my gut reaction is that seems like something one could do.
But that wasn't done at the district court.
Oh, no, no.
Questions?
Please, the court, Ellie would like to start with the Court of Appeals addressed, and also acknowledging that the appellee feels both the appellant and appellee, really because of this circumstance with this whole debate since Apprendi arose and Descamps, all the way up through Wettrick with here in Kansas, been arguing a lot of this for a long time. So the state was used, or the appellee was used to the fact that you have to have this brand new pile of information that you obtain from the other states and the other cases to make where a person's criminal history falls. And counsel also appreciates that the appellant recognizes that appellant seemed to argue in the brief that we needed to stay with or go back to the comparison test without really ever acknowledging we now have a circumstances test. statute. But here today, there needs to be a lot more focus or an understanding that we have the statute. But I would like to start with the Court of Appeals decision. Substantial competent evidence is that which possesses both relevance and substance and provides a substantial basis of fact from which the issues can reasonably be determined. State feels the Court of Appeals rightfully pointed out the factual circumstances that existed at the time of sentencing. One of the things the Court of Appeals pointed out that very relevant is the PSI wasn't just presented with topics and items that are statutorily required to be in it. That notation of residential was included with it. So with no objection by the defendant or his counsel, the PSI being presented and accepted by the court, the court having the additional notation of residential on each of those, the state feels that in that circumstance, without an objection, that rises to substantial competent evidence. So we feel that the Court of Appeals did properly analyze that issue.
But even if you assume that, why does it matter if the only thing you look at are the elements of the crime?
That's the second part of the argument, which is the real reason the appellate feels we're probably here today, is it's our position that with the new statute, you only look at the circumstance of whether under 216811 at a residential dwelling in this circumstance. And if we follow the appellant's line of reasoning, we end up going back to the pre-2019 statute in that regard, basically with the old test that we originally had. But it's obvious the legislature intended to create a new set of standards that we go by.
Well, so let's talk about the statute. I'm gonna quote from the statute. An out-of-state conviction shall be classified as a person felony if one or more of the following circumstances is present, and here's as defined by the convicting jurisdiction in the elements of the out-of-state offense. So that's the new statute, as defined by the convicting jurisdiction in the elements of the out-of-state offense. And then when you get to H, it's entering or remaining within any residence, dwelling, or habitation. So if the out-of-state statutes include entering or remaining within any residence, dwelling, or habitation as an element, then it's a person crime. If entering or remaining within a residence, dwelling, or habitation is not an element of the out-of-state statute, then it's a non-person crime. Would you agree with my interpretation of the plain language of the statute?
Not willingly.
Okay, so where is my
I-
analysis of the plain language of the new statute at 216811 E3B? Where am I flawed?
I think the intent of the legislature is.
But we're not getting to intent. I'm talking about plain language, inserting the language. We're not getting into any, I mean, the intent is reflected by the plain language, except as, unless there's an ambiguity is.
And Your Honor, if you're suggesting that you look at the elements to see if that particular subsection of the statute is met, then I would say you still look at the elements. But I don't think you go through the comparison with particular statute that we have in each state to determine whether that
Then what does this language mean?
subsection met.
But then what does this language mean? It says, as defined by the convicting jurisdiction in the elements of the out-of-state offense.
I think what that means is you still look at that jurisdiction's statute and at the elements of the crime, but you don't ask, do we have a comparative crime in Kansas with all the elements? Do we just have a meeting of that particular subsection by looking at that element?
We look at the circumstances with the colon, which is under subsection H. Okay, we look at the out-of-state elements of the out-of-state offense and compare it to subsection H, which is in the out-of-state offense, do you have an element of entering or remaining within any residence, dwelling, or habitation? So instead of comparing it to any statute that we have, the legislature said, here's H, right? So my question to you is, does the out-of-state statute include entering or remaining within any residence, dwelling, or habitation?
I think the trespass statute sets that out better than the burglary statute for New Jersey. But regard to the bare bones statement of the statute, I would have to acknowledge it does not.
Well, what, okay, let me ask a follow-up. Why wouldn't the New Jersey's use of the word structure and then subsequent definition of structure in their definitional sections include entering into a residence? And why isn't that the element? That's what the Court of Appeals said. The Court of Appeals said, this New Jersey statute includes this element. They don't use the precise exact words, but when we look at structure and we look at the definition of structure, we can say, this is the element that Justice Standridge is referring to under subsection H.
Here, I'm a little.
Why is that
slow.
wrong?
I'm considering where we were before 2168-11 was passed versus now. The appellee feels that the Court of Appeals can still interpret that way and is correct to do it that way. Historically, though, we were comparing the element and right down to the words in our
It just sounded,
statutes.
maybe I misunderstood, but it sounded like you just sort of conceded that the Court of Appeals was wrong in their analysis.
Well, I didn't mean to.
But let me ask my follow-up. Let's assume for purposes of my question that Court of Appeals analysis of subsection, there's a lot of subsections in the statute, so it's confusing, but where we're at is BI, single I. That's the subsection the Court of Appeals was focused on. Let's assume they were correct in their interpretation. I want to go back to my discussion that I had with your opposing counsel, which is if you look at B triple I, it looks like the statute says exactly the opposite thing. And isn't there just a plain contradiction there? Because what B triple I says is that it shall be scored as a non-person felony if the elements do not require proof of the circumstance. And that's clearly the case here because structure is broader than residence.
Your Honor, way I would look at it is, I don't necessarily see it a conflict because I consider the first subsection to be more specific in nature, to a very specific statement of what applies in that circumstance, and the second section to be more general. So I would believe that we would have the circumstances, if you can meet it statutorily, you can rely on the habitation or dwelling part of the statute instead of the second part. If you don't necessarily have a clear rendering in that situation, Your Honor, you asked whether of other counsel, can you go back to the sentencing journal? State would believe that it would be. Look at the sentencing journal entry because it would not be adding facts from a crime or the event that occurred, but you would merely be looking at the classification it received. So the state doesn't believe that would violate.
Does the state have the burden statute that says the state should put forth or submit the journal entries, right?
If there's an filings of the PSI state's being as a substantial competent evidence of the criminal history that exists. objection, what to do?
Did the district court advise the defendant that he had a right to a jury trial on residence finding?
Yeah, at the time of sentencing, no.
That matter?
Well, properly set out in the briefs, well, and in the Court of Appeals decision too, it acknowledges that the right to objection or concern is the defendant's, not his attorney. So,
Did he admit? Your opposing counsel said he merely acquiesced.
counsel admitted, defendant.
Counsel, if I can, I want to make sure I understand your position on the New Jersey burglary statute. Do you agree that the elements of burglary in New Jersey do not necessarily require proof that a defendant entered or remained within a residence?
I have a question. 21-6814, which sets forth the process for establishing a criminal history, an offender's criminal history in court, which you referenced a few minutes ago. The state has the burden to prove the criminal history, and you said if the offender doesn't object, then it's substantial competent evidence. But in 2022, the legislature added subsection D, which talks about if an offender raises a challenge to criminal history for the first time on appeal, that the offender can do that and designate a record on appeal that shows prejudicial error, which means that the offender could provide the journal entry on appeal. Does subsection D apply here? Or maybe you're not familiar with, I may be catching you off guard. I don't know. The last legislative session, 2022.
It would be the state's position. It does not apply in this circumstance. Thank you for your time. Nice to be here in person.
First things that my colleague here mentioned started was that, in a way, my brief, like, well, it's not comparability, it's this other test. And I will admit that when I was preparing for this argument, I was looking at my brief and my petition thinking, okay, maybe I'm confused about what the test is. Maybe I'm confused about what we can still rely on, what we can't. And so I just bring that up as an example of why we need this court's guidance about how we are to consider this statute.
Counsel, along those lines, would you agree or disagree with the notion that one of the overall purposes of the legislature's redrafting of this is to get us completely away from delving into the underlying facts of an out of state conviction because of all the problems that are associated with that?
I would agree that the offers of this and the legislature adopted that they want to try and get away from that.
In other words,
Yes.
this statute is crafted as a matter of law test. no need to delve into the underlying facts of an out-of-state conviction. At least that's the intent.
But we can call them circumstances rather than elements. The fact is that you still, even using this test, you have to look at the circumstances and compare them to the out-of-state, the out-of-state priors elements. And
Right.
so I can appreciate that we are trying to make it simpler. I don't know that that's what happened, but this idea that we can somehow, that it's going to be like a super quick process, that's just not how it is. You still have to look at the out of state. So I guess I'm still agreeing with you, I think, but I'm trying to explain that it's not as simple as some would make out, I think.
Because we
wouldn't-
still have a situation where even if that's the intent of the statute and we do want to streamline it, you still have to protect the defendant's right. Because if you have a statute that's broader, that could encompass, that defines structure as, a place that could be inhabited, but it's also a warehouse or it's a, tent or, or whatever it is, that, that there is the problem that it could be broader and sweep someone under, right? I mean, that still applies regardless, right?
Exactly. And in fact, if
I'm sorry to interrupt, but why does that apply? And this gets to the constitutional question, right?
Right.
Why couldn't the legislature just write it out, just say under New Jersey, code XYZ, it's a person felony? Why did?
They could do that.
So
In
there's no
fact-
constitutional infirmity that just because it's broader, we're only talking about how to score it.
In theory, there's different ways that the legislature could just say, well, you commit anything out of state, you can't do that. Can you? Right. Like, could they just say, well, everything's a person felony, or if you have an out of state conviction, we're going to tack on X number of months, but
Couldn't they do that?
You can't, because we do still believe, or it's our position that these constitutional concerns still come
But
into play.
what would
No,
be the
but-
constitutional concern with the legislature simply saying, there's no such thing as a non-person felony anymore? They're all person felonies. Why couldn't they do that? It would be maybe an outrageous policy, but where's the constitutional problem?
Well, I think that what comes to mind is the problems that are discussed in things like DeComp and Mathis, which I'm
But that has
I'm
to
not
do
as
with-
smart as other people on this. Sorry.
Okay, but I think Justice Stegall is right, but that's not the statute we have here, right?
Thank you. Right. What they chose, they could have left the test electric. But
They could have said, as Justice Stegall says, they could have said, you commit something out of state, it's a person felony. Our legislature, but that's not what they did,
It's not
right?
what they said. And so what we are left with is something that I would argue does require some degree of notice or whatever. But more importantly, when we are talking about the intention of the legislature and what this statute does, one of the reasons put forward by the proponents of this test was that to address, they wanted to, well, let me back up. It's really what we're talking about here is what you all said in Wettrick, that this concern that you are not sure who to include. Are we including people we shouldn't? And the ramifications of that, that's what's happening here. So if the idea was to undo that and not have that happen with this new test, it's not working because it will sweep in people that should not be swept in.
Let me ask you a question that I asked opposing counsel. Are you familiar with the addition of subsection D?
Yes.
Okay, so does it apply here?
So I thought about it a little bit, and I think that arguably if I had to go back, which I don't think I should have to, but in theory, let's say that this court says, all right, well, you can go back and argue about it below. Or let me put it this way. Sorry, I should have thought before I opened my mouth. In this particular, I think that it could apply. I also think that in this particular instance, for me to meet that burden, I don't need to produce any journal entries because on the face of this test and the face of the New Jersey statute, he wins, is my position, that Mr. Busch prevails. And it doesn't matter that we don't actually look at.
But you conceded with Justice Stiegel that there's an ambiguity here and that, you know, that structure as defined in New Jersey could include a dwelling. So the question is, did it include a dwelling? And this could be easily rectified had you just gotten the journal entry. I mean, do you automatically lose under subsection D?
No, and this is why I was answering D without even thinking about the other part. Because if the question, I was looking at it from if I'm bringing this up for the first time, well, they're work in conjunction really. And the way that I see them working in conjunction is if I'm bringing this up for the first time, which I am, then I have this burden. And what I'm saying is, I think I can meet that burden just using what I think the outcome should be about the test part, in that you, by looking at that, what does New Jersey necessarily require doesn't match the circumstances test. So I guess my point is, I think Mr. Busch prevails without producing any journal entries, and that it's actually problematic to bring in journal entries because of this idea of impermissible fact finding,
So
at least with regard to the burglaries.
I can't make a dwelling into a house, or I can't make a structure into a residence without facts. Elements test precludes me from using facts. Therefore, you win, right?
Right. Right. And I admit it's confusing because we're supposed to be having this new test, but it still requires us to look at things. And when we look at things, I believe he prevails because what is required of the New Jersey burglary is not they do not necessarily have to prove one of those things in the test.
And that's triple I. I mean, and I think everyone's conceded. This might be the clearest point of this whole case. Under triple I, this is not a person felony. If we just look at triple I, and doesn't that just, I mean, from your point of view, it would seem to me, you would say case over. As a matter of law, this sentence does not conform to the statute, therefore it's illegal.
Right. And that is what I finally came down to last night, which is this is simpler than I thought. Because if I agree, we have to say that the statute's ambiguous, and which triggers certain things for Mr. Busch. But yeah, it seems that it's easier than I thought. If it comes down that triple I controls, but has to be construed in his favor, we're done.
I can connect those dots on the burglary.
Right. And I do sort of speak of them as, grouped together, but back to what Justice Rosen and you too, Chief Justice, were talking about, I will, and Justice Wilson, that I will admit that the criminal trespass part is trickier because it does use the word dwelling. And I hadn't thought about the fact that the sentence could tell us something about which one that was. But as far as burglary, I just feel like we're done if. And at any rate, if there are, may I wrap, Chief Justice, may I wrap? Okay. At any rate, I would just ask this court to, I think our whole state desperately needs to hear from this court about what the statute means, how it works. And we would ask that you rule in Mr. Busch's favor. I think I've had Justice Stevens.
Like he was ready to ask a question.
Only is a very technical one. If we rule in your favor on the burglary criminal history, but not in your favor on trespass, does that change the scoring?
That's right. And I thought about that, and the answer, I believe, is that it goes to being a B, because He had one, so there's one trespass.
So it's not moot, in other words.
It's not, no,
Would make a difference for your client.
he would, I believe he'd become a B from being an A.
All right.
Thank you.
Thank you to both counsel for your arguments. Court will take this matter under advisement this time. What that means is that later today, the court will conference this case and we will talk about it. We may not finish our conference today, but we will at least begin it. And that once we have completed the conferencing, we will then draft an opinion. Matter will be filed through a decision, a written decision. There will be a press release that announces the publication of that decision, and it will be placed both on the places that law students are used to going, probably of Westlaw, Lexis, or other online, but also on our website. For thank you, counsel. That I will now ask counsel to come forward on case number 124676, State versus GO.
Hey, please the court. I'm Reed Nelson. And I'm representing GO, who was a juvenile at the time. The case is before you on our petition for review. GO had been charged with a number of counts of aggravated indecent liberties with a child. And we had a pretrial hearing where Judge Parrish suppressed his confession after hearing from a couple witnesses and watching the video of the confession twice. And the state appealed. The majority of the Court of Appeals panel reversed Judge Parrish. There was one dissent by Judge Hurst. The issue on appeal, and I think that encompasses the standard of review, which is very important because I don't think that it was followed up until now, is simply whether there are facts and inferences from those facts that support Judge Parrish's determination that this was a coercive interview because the detective misled GO as to the purpose of the interview and also made promises to GO of benefits if he would talk. Those were her findings. That was her judgment. And all we're looking for are facts in support of that. This is not a reweighing, in other words. All parties agree that the detective initially separated GO from his mother to talk with him. And from that point on, it was very light-hearted. The detective is dressed very casually. He sits back, he says, this won't take long at all. We'll have you out of here real quick to go to your orthodontic appointment. And then he begins misleading him. Tells him, this isn't about anybody getting in trouble. This is about trying to fix things. Then he tells him, you're not going to be under arrest. He says that twice. Nothing could have been further from the truth. He then continuously begins to mislead GO as to the nature of the interview, promising that this will help out everybody. My job, he says, and he misleads him on what his job is. This is a detective who conducts criminal investigations. He tells him, my job is to work with little kids. He says, this will help us move past it, and it'll help you and your sister. This is now a therapeutic ploy that he begins to, and uses this throughout the entire interview.
Counsel, let me give you the same hypothetical I'm going to give the state, which is assume with me that the officer had not given the defendant any Miranda rights at all. Everything else is the same. When?
Yeah.
In terms of, do these statements then for sure get suppressed?
Yes, Your Honor. because this was coercive. The Miranda rights are actually irrelevant in this case. The police cannot coerce anyone, ever. They cannot go on the street right now and coerce someone to talk. Miranda rights are not. Now, he gave Miranda rights, which the prosecution is going to argue, well, that alerted to Geo to what was actually going on here.
Right,
Right,
that's
that's
the,
their
that's,
argument.
that's the red balloon that the Court of Appeals, the majority on the Court of Appeals and the state relies on. I'm just saying, okay, and so for me, that red balloon then has to have a context, which is what fits into your argument. But I'm starting with the premise that no rights had been given at all, and you're saying it doesn't matter because of all the other context.
Coercive.
Okay.
It was misled him, yes. And the Miranda rights were simply nullified because in the same breath, did you notice in the same breath that he gave the Miranda rights, he said, you're not going to be in trouble. Or something to that, I don't remember if it was you won't be under arrest or you won't be in trouble. I get those confused, but he said, well, Miranda rights tell people that they might get in trouble.
Isn't
Right.
it essentially settled law that lies during an interview can never rise to the level of unconstitutional coercion?
Can never rise to the level?
Yeah. That the law enforcement has leeway constitutionally to be untruthful.
Oh, I don't agree with that, Your Honor. They have leeway to be untruthful as to the facts of a case. So you can have the suspect come in and say, we found your DNA. And they didn't find the DNA. So
What's
what's
the difference between that and you're not, my job's to work with kids and whatever else he said?
That's misleading them as to the fundamental legal status of that interview. That is the foundation for everything that comes. That is the Morton case where the suspect was called and said, I'm going to come in. Do I need a lawyer? And in this court in Morton's said that was coercive when they said, you know, come on in. You don't need a lawyer. It's not that kind of interview. That misled him. That was a lie. That was an investigative interview, just like this was, but that misled him. Because that's the foundation for your rights. If you don't know what kind of interview this is.
Isn't that why the Miranda warnings are actually important here?
Yes, well, that's why they would have been important had they not been interfered with in the same breath by indicating that they don't matter. That you're not going to be in trouble. So why would the Miranda rights even matter?
Could we get
Just
back?
under-
No, go ahead, Chief.
Go ahead.
Well, getting back to where you started with the standard of review
Yes.
and what the Court of Appeals did here. It just seems to me then looking at this, according to kind of your view of what the standard of review is, and whether there's facts and inferences that supports the district court's decision in the first place. Talk to me about the reweighing on the educational factor significance, because it does appear to me as I look at it, the district court viewed it in a different light than the Court of Appeals. And
Yes.
where's the tension and the friction there, and why is the Court of Appeals wrong in what they did?
Right. This is the whole problem, Your Honor. The Court of Appeals accepted the invitation to just look at the video and make their own decision. That's what they did. They looked at the video of the confession and they became the fact finder. The Court of Appeals became the weigher of the evidence, and they looked and they thought, well, this child looks like he's reasonably intelligent. We don't think this was coerced. That stepped out of the boundaries of their standard of review. That was a giant step outside the boundaries of their standard of review. They are not the fact finder. Judge Parrish watched that video twice. And not only that, but it was a lengthy hearing where she listened to evidence from the detective himself.
Well, and also offered an explanation as to her understanding of the educational significance.
Yes, she considered it, she weighed it. And,
Exactly.
she listened to the mother and judged her credibility about all the educational issues the child had. And she is allowed to weigh all that. It is inappropriate for the Court of Appeals to simply jettison all that and say, well, we don't see it. Well, they don't see it because they didn't listen to the evidence. And it was crucial in this case also for fact finder, Judge Parrish, to listen to the testimony of the detective. Because when you look at the transcript of the testimony of that detective, he is confronted by the defense attorney during cross-examination repeatedly as to all these misleading statements. Even on direct examination, he talks about it, and he never backs off what he said. He never qualifies what he said. Not a single time does he ever say, you know, when I said that he wouldn't be arrested, what I meant was that he wouldn't be arrested when the interview was over or something like that.
So did that rise to the level of a promise?
Yes. Oh, yes. It was definitely a promise. He said, he told him, you will not be arrested.
Was it indefinite? I mean, he wasn't arrested after the interview.
Both times were indefinite. He says it twice. And the first time he says, you will not be arrested when we're done. That's arguably open-ended because he was 2 years later. But then the second time he says, like I said, you're not going to be arrested. Well, he was. And he wasn't just arrested. He was arrested on major felony charges. And even more important, Your Honor, he said he wouldn't be in trouble.
Let's,
Except there was an exception. Did say you could be in trouble if you don't tell me everything. And is that important as we weigh the Miranda factor, as we talk about the Miranda factor?
Yes. It's the continual promising that he's not going to be in trouble, that nothing bad is going to happen to him. What reason would anyone have to take their Miranda rights if they are assured by a trusted adult, someone who's acting as a pseudo-therapist, that this isn't that kind of a proceeding? This is that kind of interview. No one would have any interest in taking their Miranda rights. There's no need to.
Why would that? Just big picture, all of this falseness as you're describing it, which I agree with you. I mean, obviously it's a deceptive technique, but why would that prompt a false confession out of this defendant? One of, not the only, but one of the legal concerns with coerced confessions is that they're false. I mean, someone is getting tortured, let's say, and then they're going to just say anything. To me, this doesn't strike me as, oh, I'm not going to get in trouble, so I'm going to make a false confession to doing these awful things.
Well, it could, if you think that that person has the power to arrest you and they're not doing it.
So you're postulating that your client may have been sitting there thinking, I didn't do this, but he's going to arrest me anyway, unless I give a false confession.
Well, I don't necessarily go along with that with my client. I'm going to take a step back. I think that's answers your question in terms of how this ordinarily could work. And this is why police detectives don't usually do this, and they shouldn't do this. But in terms of our case, I just stop at the idea that this is coercive. You can't. Is right.
Just
And
go ahead.
no, essentially, so then under the standard of review, it's our role, as I understand your argument, to just take the findings that the district court made. And then the question for the state then, or to overturn the district court, the state would have to show as a matter of law that these findings, we're assuming they're supported by substantial competent evidence, but those findings as a matter of law cannot render a statement involuntary. Is that essentially the state's burden when we're reviewing or an appellate court's standard of review?
Yeah, that's correct. And that's why, honestly, I mean, I think the state's position has to be very difficult in this case because they're not disagreeing with us as to the law.
Yeah, it's not, that's my understanding of the state's position here is, look, we're not disputing any of the facts found by Judge Parrish. We just are simply saying that those facts, as a matter of law, do not render this confession unconstitutional.
And Your Honor, they're not disagreeing as to the law itself. They don't think that the law allows a detective to trick a child. They don't think that the law allows a detective to mislead a child and lie to a child in order to get him to waive his rights or in order to get him to talk, which is exactly what happened here. They don't even disagree with that, as far as I can tell. So they are asking you to reweigh the facts that Judge Parrish already weighed. That is what is happening. They asked the Court of Appeals to do that. The Court of Appeals accepted the invitation, watched the video for themselves, and just started from scratch without ever hearing from the detective. Without ever hearing.
Let me ask it just a highly conceptual question. When we're asking the ultimate question of law, what does reweighing mean? Because there is a weighing component to reaching the ultimate legal conclusion.
Right. There's always that element to it. This is more, to make it simple, what I feel like the job of the appellate courts is at this point is exactly what you set out in your cases, to look for facts and inferences from those facts that support the trial judge's judgment, even if the trial court didn't make the exact factual finding.
Well, isn't it? It's evidence and inferences that support the district judge's fact findings. But if we're really not questioning any of the fact findings, there is still an element of weighing that goes into the legal question. We get this all the time in these, I mean, like Fourth Amendment cases, probable, like reasonable. We always get into this fascinating area where we have a set of facts that we're not going to reweigh, but then we have to consider all those facts in reaching the ultimate legal.
I think what ends up happening is that you look to see if it's reasonable. Is it so unreasonable? I think sometimes is the factual finding so unreasonable? And I will comment before I sit down that in addition, Judge Parrish didn't need to make factual findings on every single fact. Didn't need to do that. She made 3 pages of factual findings and did exactly what she was supposed to do. I think the state has problems that she didn't make certain factual findings, but that's where, again, the standard of review is that you find facts, you find factual inferences that support her determination. She can be right even for the wrong reason. She can be right for any reason. So it's not necessary for her to make, and the facts were not in dispute below. Prosecution didn't ask her to make any factual findings because they weren't in dispute. The witnesses agreed with each other.
And part of the problem is that the ultimate conclusion, the legal conclusion, voluntary versus involuntary, is just a mushier legal standard than whether or not someone was had the right of way or was running a red light. So does this court then owe some deference to the legal conclusion made by the court? Or is it simply a matter of the state must prove that she was wrong?
Well, that just answers your question. Yes, it is a little bit mushier. But it's driven by the facts and the inferences. I believe this is driven by the facts and the inferences, and the facts and inferences that support her judgment are from beginning to end.
So it's simply that the state must prove that the inferences made by the court finding the statement to be involuntary must be
very unreasonable or something.
Isn't the ultimate standard the totality of the circumstances? That what we look at for voluntariness?
Right, that's correct. Yeah, under the totality of circumstances, and who in a better position to look at those totality of circumstances than the judge who's looking at the credibility of the witnesses in front of.
That's a legal question. Totality of the circumstances is a legal question, which is reviewed de novo.
That is reviewed de novo, considering the facts that support that. Yes, that's correct. Okay. Thank you.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. I plan on covering 5 topics if you'll let me, and probably not in the order that I intend. But first, I want to touch on the standard of review. Second, the facts that were actually made, or the factual findings that were made. The fact that Miranda matters, the fact findings that have been manufactured by GO in the dissent in this case, and then maybe RW's application, though I'm undecided on that one. The standard of review, I just heard him say all the facts are undisputed. Okay, then the review is de novo. We take the facts that are undisputed, and this court has de novo review over the totality of the circumstances analysis, which is a legal analysis. My issue has never been with the 4 facts that the district court found. My issue is that those facts do not amount to coercion here. And those facts are that GO didn't have prior law enforcement experience. That's true, but that doesn't amount to coercion, at least by itself. The fact that he had educational issues and he had anxiety. Those are probably the 2 most problematic factors in the state's mind. We can't say law enforcement can't interview anyone who has anxiety. I'm not sure how much of the population law enforcement would still be able to interview. The educational issues, I will say yes, some educational issues on their face. The person's educational understanding is so limited, the officer will immediately know, and that interview probably can't happen. Maybe it's called low functioning autism, something like that. It would be readily apparent that officer would not be able to do an interview. Here, though, the educational issue, which I'm still not entirely sure what it is, if it's the ADD or some other unspecified mild learning disability, the accommodation was one-on-one setting. The interview questions were read to him. Well, that's what the officer did here. We accommodated any possible educational issue. And I don't see how and I think even in his most recent briefing, GO says he understood the questions. And if you watch the interview, you can see he understands the questions.
I'm gonna step on Justice Biles' toes because he already said he was gonna ask you this, but I'm gonna ask.
We'll be talking about respect for seniority.
Later. Okay. Okay, let's talk about Miranda.
Sure.
Okay. Because in your brief, and the Court of Appeals majority found that was a factual finding in support of voluntariness, was that GO received the Miranda warning. So what is the purpose of a Miranda warning?
The purpose of the Miranda warning is to inform you of your rights.
Why?
So that apparently we assume people don't know them so that they can then invoke them if they
And
choose
you
to.
give a Miranda warning, when do you give it and when do you not give it? Do you give it when you're the target of an investigation?
Typically, yes, although the Miranda is only required in a custodial interrogation. And
Okay.
so there is some dispute, especially in Shawnee County. I think a judge has found that just being in the police station is a custodial interrogation. So officers will give Miranda even if they think, and I think this officer may have thought this was not a custodial interview, but gave the Miranda warning just out of an abundance of caution.
Okay, so, but is it undisputed that he was the target of this investigation?
Yes.
Okay, so the purpose of the Miranda warning is to say, I pulled up the Miranda warning so I could have it. Where is my Miranda warning? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you can't afford attorney, we'll get you one. Okay. And then in the next breath say, or even before you say that, to say, hey, we're in this room, so I'm going to give you this Miranda warning. Or he doesn't even say Miranda warning. I'm going to give you this. I'm going to tell you this. Okay. To what extent does that even negate the Miranda warning?
I don't see how, hey, we're in a room, but here are your rights, negates the Miranda warning. I do not see that. I understand that that's GO's argument, that somehow the fact that
while we're in a police
But
room.
didn't
Okay,
the
let's
officer-
add to the fact that right after that, 5 or 6 times, he says, you're not under arrest. You're not going to be under
Does
arrest.
not say you're not going to be under arrest after Miranda. I do
Oh,
not
yeah,
believe.
yeah.
He says before,
Oh, immediately before.
immediately before,
He says it immediately before, but he
And
repeats
he
that.
says, he only says the not under arrest thing in my, and I apparently left my transcript in the room, but he says, the first one was, you're not under arrest, or as I told your mom, you're not under arrest. Yeah, I know. And you're not gonna be under arrest when we're done. Then he goes on, and maybe that was after Miranda when he says, like I said, you're not under arrest, and then they keep going. And then Gio immediately starts to mitigate everything that's happened. But the fact that he's not under arrest, again, goes to custodial, not custodial. If you want to say that you're not going to be under arrest is a promise, and I think we need to get there, that is different than, that doesn't negate Miranda. Miranda
Saying that-
says,
When you're saying that in conjunction with the reason we're here is because of your sister. We just want your sister to get better. You're not under arrest. You're not in trouble. We just want your sister to get better. The only way you're going to be in trouble is if you don't tell the truth. When you say the Miranda warning, you have the right to remain silent. I mean, to me, it just seems
he does have the right to remain silent. He can stop talking, and he was actually told he could have an attorney present in the interview. He did not invoke his rights.
But why would he invoke his rights when immediately before and several times afterwards, you're saying, you're not in trouble?
He only says this isn't about getting in trouble before Miranda. That statement is a before Miranda statement. He then says, we can use your statements against you in a court of law. I think that negates any kind of, this is a free for all. You can get out of jail no matter what you say.
Why is it?
Talk about Garcia. Can you talk about how Garcia fits in with the?
Remind me which one Garcia is. I'm
Garcia is the
sorry.
one where the officer uses the girlfriend. to
Yes.
Say, hey, they're not going to charge you with first degree murder. So just confess to the other crimes.
Right. And here there was no promise. I'm sorry.
Well, and then what I was going to say, and couple that with Judge Parrish's finding, or comment at least, and this is in the portion where Judge Parrish talks about what really tips the balance is that Gio believed he was at law enforcement center to talk with Sergeant Hayden about how to help his stepsister, and they go on. And then a few sentences later, Judge Parrish says, talking of the mother, she testified that she told him, talking about Gio, had to talk with the detective. They were all trying to cooperate for the benefit of the stepsister. And does that fit squarely with the situation in Garcia where we way to distinguish Garcia?
No, I don't think it fits squarely within Garcia because apparently, yes, the mom said that she thought they had to talk to him. And I think she said that she told Gio that as well.
And she also told him he would not be arrested. Sergeant had
The
said,
detective said he would not be arrested when we're done. That is actually,
that's not what the mother, and in fact, that's when the officer repeats to Gio, he says, your mom probably told you won't be arrested. There was no, when we're done qualification.
that's when, but prior to that, he said, like I said, which refers back to the not and arrest when we're done. And my biggest problem with all of this entire conversation is that was argued below and Judge Parrish did not say, yes, I believe he had some kind of promise or benefit. That factual finding was never made. And this court is not a fact-finding court.
But she did say he had no prior law enforcement experience.
Yes.
From that, a whole plethora of inferences can be made, including those, can't they?
I think that's basically this court making fact findings. No, I don't think the fact that he had prior law enforcement experience has anything to do with it. But I think it's also common for law enforcement. Usually they say today, and yes, I wish this officer had said you're not going to be under arrest today. That is common in almost every sex case I ever see, because we don't often arrest in sex cases immediately.
Usually the officer also says after reading the rights, do you waive those rights?
Yes,
And he didn't do that.
right.
Why is it so hard for this detective to just, or this officer, to just tell Gio that at least a part of what he is doing in interviewing him is investigating a crime.
I don't know
Why is
any
that
law
so hard?
enforcement officer that comes in and says, here is what I'm doing. I'm investigating this crime. Gio knew what he was doing when he was there. I mean, how do I know? He immediately knows. He immediately says, without any question at all, I was abused as a child and that's why I did what I did. The entire interview is him mitigating, trying to get out of like, I stopped every time she said stop. Yeah, I would do that. It was him mitigating the seriousness of his actions. He wouldn't do that if he didn't think he was in trouble or he was being interviewed. And frankly, I find it just
But isn't that
little
fact
bit-
finding? For you to say it wouldn't say that for any other reason? Aren't there in fact a lot of other reasons why he may have said what he said?
maybe.
He knew his sister was having problems. He knew his sister was making claims. He
But
knew-
how does telling law enforcement
knew
during
his
an
sister
interview
was-
help him?
He knew his sister was in therapy,
Yes.
and he had been told the purpose of this interview was to help his sister.
And my problem is that a defendant confessing does help victims. And I also find it just entirely unbelievable personally that any 16-year-old thinks a detective interviewing me is the same as therapy. I don't know how we're getting there.
Is that because you have law enforcement experience?
I think even at 16, I'd watched enough Law and Order to know that cops don't just go around being like, hey, I want to have therapy sessions. And this kid is in therapy. He knows what a therapist is like.
The point I'm trying to make, though, is it's not to make,
Right.
we all have to worry, we all have to guard against fact-finding and inference making, which the district court had the total right to do.
Right, but here for the undisputed facts, you either have de novo review, or if in fact there needs to be additional fact finding, I don't think this court should be the one to make every single fact ever. The state did object. It objected when it filed a notice of appeal and it pursued an interlocutory appeal. At that point, if you want additional fact findings, send it back to the district court to make additional fact findings. But I don't think this court is in a good position to say, based on what Judge Parrish found, that she inferred that the mother was used, because that wasn't even argued to her. So how in the world did she make that fact finding?
Why does she have to use the magic words of benefit? That Garcia sets out a three-part test. And if she made the findings that meet that three-part test, isn't that sufficient for us? Garcia to say that there was a.
I think she would have had to say something that would have clued in that was a benefit. She said he was there to help his sister. That's true. He admittedly says repeatedly in there that he wants to help her. And I also think that defendants confessing does help victims. It helps them not be gaslit. It helps them think that they're actually what happened to them happened. Does it help him? No. I think the lie here is not that he was going to help his sister. The lie was, even then, he said not about getting anyone in trouble, but the idea that it would help him at all. Because of course, a confession is probably not going to help a defendant, although it could if he confessed in a way that not probably in these kind of crimes, but that maybe he would have done it so that we would have still tried him as a juvenile instead of having him tried as an adult, or his confession would have been mitigating in some way that we wouldn't have apparently charged 60 some odd counts.
They get to use this statement if the officer had not given the Miranda warning.
No, I don't think so here, because there's nothing to negate that you're not in trouble thing. I think that's a problem if there is no Miranda here. But I think Miranda matters here because he says this isn't about any trouble, and then says, but we can use this against you in court. You have a right to an attorney, you have a right not to talk. And that also negates what the mother said. I think in Garcia, the difference is maybe, I don't know if Miranda was given in Garcia. I'm gonna admit that I don't remember that case perfectly, but here, after the mom said, you need to go talk to him, he was told you have the right to remain silent and you have a right to have an attorney present in this interview.
So but kind of the follow-up of my idea is, if Miranda is that significant, then also the context in which Miranda is given And that's where the statements by the officer that at least Judge Parrish believed took away from the seriousness of the rights that had just been given to this kid. That's where that's important. So I think it's fair to look at what the officer said and the context in which these Miranda statements were given to determine whether they were effective.
He said, do you understand your rights? Yes, we didn't prevent him from exercising any of his rights. We told him what his rights are so he knew what they would be. I'm sorry, but I just don't see how what the officer did here made him unable to understand his rights, unable to invoke his rights, and unable to stop talking if he didn't want to talk or not have an attorney. Nothing undermined the actual rights themselves, which he said he understood, and there's no indication that he wouldn't have been able to understand that, which is typically where we look at, is something coercive? Was he able to understand his rights? And then was there some kind of, well, it is a very wishy-washy standard. I think even Lefebvre complains about that and the fact that the totality of circumstances is tough standard. I lost my train of thought there.
I'll
You look
jump
like
in
you have a
and ask
question, so.
If this court concludes that the Court of Appeals misapplied the correct standard of review, what should happen?
I guess you could do the test for them. I mean, you could correctly apply it or you could remand it back. And I've never
I
quite
guess I'm asking
understood.
which do you think is proper in this case?
Just in the interest of moving this case along, I think it would be great if this court would do it, but I don't understand honestly when you guys do it and when you remand it. That's always seemed like a your call, not a my call. But I think this case has drug on quite a long time, so it would be great if it's allowed. I don't know. If it's not, then it's not. It's the state's position, again, that the fact findings that were actually made by the district court. I think, to me, the first three don't have any effect at all. The one that I think is the issue is whether or not he was misled. And the district court didn't say that Gio was misled. She just said he believed he was there to help his sister. And that factor to her was so overwhelming. There was coercion. And I think Miranda negates any kind of issue with that factor. And so for those reasons, the state would respectfully request that you affirm the Court of Appeals or at least reverse the suppression in this case. Thank you.
Address a couple of the points that were made. I think Justice Biles asked, why is it so hard to just tell a suspect that you're investigating a crime? Well, it's not hard. And that is usually what professional detectives do. I mean, they usually will look at someone and say, we've been told this by this person and we'd like to get your side of it.
Know that. I mean, is that from TV?
Well, I don't know. I just not on the record, but it's argument, Your Honor, it's argument. And the reason why the detective in this case did not do that is because the detective wanted to pull the wool over Gio's eyes. And the detective was concerned that if he indicated that this was a criminal investigation, Gio might not talk. Gio might invoke his Miranda rights. The detective didn't want that. And we're talking about what was said, what was meant in terms of the whole arrest thing. Detectives' direct examination by the prosecution, asked by the prosecution, after you sat down for the interview, what happened? The detective said, we spoke a little bit. I told him that he wasn't under arrest and he wasn't going to be under. Then I read him Miranda. That's how the detective characterized it. And that's what he said. You're not going to be under arrest. So why clear messages, talk to me. Nothing bad is going to happen to you. That is the clear message that is being given to a 16-year-old child who is suffering constant panic attacks, who's separated from his mother, who relies on special education in order to graduate. All the other things that Judge Parrish heard. She was allowed to weigh all of it. Thank you.
Thank you to both counsel for your arguments in this matter. The court will take this appeal under advisement. The court is in recess until 9 a.m. tomorrow morning. All right.